Good evening, everyone, and welcome to a regularly scheduled meeting of the Penfield Zoning Board of Appeals. This meeting is being video recorded and broadcast live on Penfield TV's Government Access channel, which includes Spectrum Cable 1303, also online at penfieldtv.org, and social media platforms, Facebook and YouTube via Town of Penfield Television. Following the proceedings, the video recording will be available on the town's website and on streaming devices Roku, Apple TV, and Amazon Fire. You only need to search for Penfield TV in your device's app store, and you should know it is free. If anybody wishes to address the board tonight on any public hearing matter, there will be public participation opportunities following the applicant's presentation and questions, comments from the board. Those opportunities will include calling this phone number here. If you want to call in and make a comment, you can do that. Every once in a while, you'll see me reach for this computer. That just means I'm checking to see if there's anyone in queue on the phone. Another way to do it is to submit an electronic comment or question through the town's website at penfield.org. In fact, we have one sitting there already. And then, of course, another way to do it is to be here and present. At some point, I'll ask, does anyone in the audience care to speak about this application? But in any event, whoever comes up, whether it's the applicant or a witness, we just ask the folks to come up to these microphones and give us their name and address, and then go ahead and speak about the application. We like to point out every month that we really think the town does a good job of making sure that citizens and people in the area are aware of what's on our agenda. And why does the town do that? The town does that so that folks are more fully informed of their right to come in and speak about the application. All right, how does the town do that? Different ways. One way is to post the agenda on the website, post it here on the bulletin board. Also, the town sends postcards to people that own property or live within a certain area of the subject property. We've all probably received those postcards. And then the town also requires the applicant to put the sign out on the property. I'm sure we've all seen those. Looks like kind of a big for sale sign. This property is under review, and if you have any questions about what it's about, call that number and you can find out more. Again, we welcome the comments. We think it helps us do our job better, and we do appreciate that. So tonight's meeting, we're going to start really soon with a work session where we'll entertain a motion to approve minutes from a prior meeting. And then I don't think we have any tabled matters, but if we did, we would take care of those before we moved into tonight's public hearings. So, with that being said, I'd ask everyone to rise and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Great. All right. Thank you. And the next item on the agenda is the approval of the minutes from the June meeting.
I'll make a motion to approve as written.
Second.
All right, we have a motion to approve those minutes as written in a second. Any further discussion? All right, all those in favor?
Aye.
Aye. Okay. We don't have any tabled applications, so I think we can proceed right into tonight's public hearing. So, Andy, if we could have the first one, please.
Sure. Christopher Sobolewski, 3408 Atlantic Avenue, Penfield, New York, 14526. Requests approval for area variances under Section 250-14.3 of the code to allow a taller fence than permitted under Section 250-7.1-D1A and Section 250-7.1 D1B of the code at 3408 Atlantic Avenue. The property is currently or formerly owned by Christopher Sobolewski and is zoned RA-2, SBL number 110.03-1-10.1. This is application number 25Z-0004.
Anybody here on this application? All right, well, I know that we informed the applicant that we were looking for an updated survey, and we would need that really before entertaining anything, so perhaps they took that under advisement. But in any event, we'll call it again. If anybody sees the applicant come in, maybe we can get that word to them. All right, let's move then to the second application, Creek Street. Please, Andy.
John Wurzbacher, Blessed Hope Community Church, 1280 Creek Street, Webster, New York, 14580. Requests approval for a special use permit for signage under Section 250-10.3-A of the code to allow a second freestanding sign, whereas a maximum of one freestanding sign is permitted under Section 250-10.12-C of the code at 1280 Creek Street. The property is currently or formerly owned by Blessed Hope Community Church Incorporated and is zoned limited business. SBL number 093.15-1-2.115. This is application number 25Z-0020.
Hello.
Hello.
Again, if we may have your name and address.
My name is Sam Malakowski. The address is 1280 Creek Street in Penfield.
Excellent, thank you. So you're here tonight because you're looking for a sign at the front of your, or I guess on the side of your building to direct people down Penn Web so they know where to go and park at your church.
Yeah, right now there's a bulkhead sign. That sign, many of you probably have seen it. It used to say Bernie's Bouncers on it. It's a pretty iconic sign there. That sign is on Sovereign, and we don't have an entrance on that street. It is on our property. I'm not 100% certain in terms of the legal aspect of that, but it's a pre-existing structure on the property. We are looking to place a sign on the opposite corner, similar in style to the signs that are in adjoining businesses, including one across the street and two in other parts of the streets within one or two buildings of that one. Similar height, similar dimension, and we just need the variance to place another sign on the property.
Sounds good. And just to clarify, what makes this one unique is because there's already a sign there, and so town code allows you to have one freestanding sign, one building mounted sign. You're here because there's a sign on your property, but it doesn't service your property. It services the entrance on Sovereign Drive, so you need a variance to get a second sign. The sign's not going to be any larger than allowed by code. It doesn't need a variance for setbacks. You're just here because you'd want to put a sign for your property to direct your visitors to your church.
That's correct. And by the way, I'd like to thank you guys. It's been, in this building process, you've been extremely, it's been great. I've heard stories, and I have a good story, I guess, to tell.
Stories about us?
Yeah, you guys. And the people that come out and inspect. But part of our original plan, though, did include landscaping around the other sign, and we intend to do something similar with this sign. We see it as a part of the property that we, although it doesn't benefit us directly, we do want to keep it in good repair and looking good. So
Excellent. Based on what I'm seeing here, with the distance, since you don't need a setback variance, it's not going to block the sight line for traffic for people pulling out of Penn Web onto Creek Street, so there's not any issues that's seen with that right now. Will the sign be illuminated in any way?
our plan right now is not to illuminate it.
Okay. So there's no issues with, lights in terms of shining in traffic and things like that at this point. The only comment I had was, would it make sense to have it closer to your parking lot so then people see it more as to turn in here versus 20 foot from the side of the road instead of like maybe have it 35 foot? That was just more of my comment in terms of a perception. So people have realized that it's for turning down Penn Web and not necessarily to drive past and then turn in. So that's just more of a, it's not necessarily, since you're not here for a setback variance, that doesn't impact that, but that was my only observation when I went on site and kind of looked and said, would it make sense to have it closer? to direct people your way.
Would you recommend moving it into the property
That was
more,
my, I mean, that's just from a layman's, seeing it, that's the only thing I saw is would it make sense as you're trying to direct people down Penn Web
Yeah.
to have it closer to your parking lot so people see it and then see your driveway pulling in off of Penn Web there,
Okay.
as opposed to closer to the sidewalk on Creek Street.
Yeah.
That was my only observation that, it may be that when your sign person comes out there, they say, no, this still is the best spot for it because they do that for a living.
Yeah,
Okay.
I had the same perception when I drove over there, so.
Okay.
Okay, that would be in our future application for the actual sign, right?
I don't think they need an application for a sign here, do they?
Well, they need to get a sign permit.
Correct.
Even the location is proposed, it's meeting the setback, so if they want to move it further back or closer to the building, that's not a problem.
Yeah, so you most
Okay.
likely won't have to come here unless you're asking for something larger or you need a variance of some type that's outside of what's allowed by code.
Great.
Okay. That's all I have for here. There's nothing that stuck out.
Okay. I don't see any electronic comments, nor do I see anybody on the phone. Anyone in the audience care to speak about this application? All right, let's move to the consideration, starting with the seeker.
Okay, I'll declare some unlisted action and make a negative declaration for seeker.
I'll second that. All right, so we have a motion under seeker and a second. Any further discussion? All those in favor?
Aye. And then to the merits, looking through this, the sign is similar to other signs in the area, so it is in harmony with the neighborhood. There was nothing detrimental that was found that would impact where it's sitting in terms of blocking traffic sight lines or anything with the sidewalk for pedestrian safety. There was nothing identified that showed that it should, that it couldn't be there. I mean, you're really here because of the hardship of a sign already pre-existing when you purchased the property to be there, and that's what you're here for, is to get a sign for your place that suits your entrance side.
That's correct.
So with that, I'll move to approve.
I'll second.
Okay, we have a motion to approve the application with a second. Any further discussion? All those in favor?
Aye.
Okay, good luck.
Thank you very much.
You're welcome.
Have a good night.
All right, so we have the next application, but before you read it, Andy, I just want to let folks, I assume most people remaining in the room are here for the remaining two applications, which is fine. But I just want to let you know how we are going to handle this. I think it's probably the most efficient way, and will give folks the best opportunity to be able to come up and speak their mind about it. So before us tonight, we have two related applications. I'm sure you're all aware. The first one, and the next one actually on the agenda, is an appeal of a determination of an authorized town official relating to the original application by Chick-Fil-A, which was made in December of 2024. That hearing, the one Chick-fil-A from December of 2024, we did leave the hearing open. So tonight, we're going to be taking testimony, evidence on both matters. And we're going to sort of allow folks to come up and give us the testimony on both. Really, they're related, so there's a lot of overlap. That's fine. And then when the testimony is done on both number 3 and number 4, then we'll close the hearings and we'll proceed with action on both of them. What I want to say is that I want to make clear that we're going to give everyone a chance to speak. This application's been around for a long time, and there's a lot of arguments both ways and a lot of passion, and we appreciate that. The only thing that I would ask is that if you want to get up and say something, great. But if what you're going to say has already been said, if you can repeat it kind of quickly or concisely, fine. Or if you Mr. Jones made a point and you agree and you just want to come up and say, I agree with everything Mr. Jones said, that's fine too. That'll get in the record. Again, I'm not saying that to limit anybody's, because, we could have put a time limit. I didn't want to do that. And, there's a number of people here, which is great to see, but it's not an overwhelming number, to be honest, and certainly there's familiar faces. So in any event, with that backdrop, I guess, I'd ask you to call the next application, please.
Do you have a preference as to order, or
3,
number 3 first?
yeah,
You want me to read them both?
sure.
Okay. Jacob Zoglin, Esquire, Underberg and Kessler LLP, 300 Bausch and Lomb Place, Rochester, New York, 14604. On behalf of Preserve Penfield Incorporated, requests an appeal of the determination by the Town of Penfield authorized official under Section 250-14.5-A of the code that a Chick-Fil-A restaurant proposed for development at 2051 Fairport 9 Mile Point Road is a conditionally permitted use. The property is currently or formerly owned by No Look Landing LLC and is zoned limited business TF overlay, SBL number 125.17-1-9, application number 25Z-0016.
Okay. Again, name and, although we know you well, name and address, please, for the record.
This is pick me up. There we go. Okay. My name is Jacob Zoglin. I'm a partner at Underberg Kessler, a law firm here in the city of Rochester. And my address for the law firm is 300 Bausch and Lomb Place, Rochester, New York, 14604. But of course, you have my contact information for more correspondence. Good evening. My name is Jacob Zoglin. I'm an attorney at Underberg Kessler, as I mentioned, and I'm here tonight to speak on behalf of Preserve Penfield in support of the ZBA appeal from Carrie Ivers' March 14th interpretation regarding the Chick-Fil-A project. As a preliminary matter, appellants do have standing. Preserve Penfield includes dozens of residents, some of whom live within a mile of this project. Their close proximity gives rise to a presumption of standing as a matter of law. They also use the adjacent parkland for recreational and aesthetic purposes, which also confers standing. Preserve Penfield and its members are concerned about increased traffic and congestion, safety issues, negative impacts on nearby neighborhood and parkland, and failure to comply with the code. They also include impacts that are different from those suffered by the general public at large. These are not just vague complaints, they're legitimate, localized harms that give rise to residents' legal standing. Under New York law, they have standing because they are aggrieved by the zoning determination and have concerns within the zone of interest to be protected by the statute. In addition, the Penfield Town Code confers standing to interested parties, and I think there's no doubt here that Preserve Penfield and its members are interested in this project and application. Preserve Penfield also has organizational standing because one or more members has standing. The interests sought to be protected are germane to its purposes, and the participation of individual members in this appeal isn't necessary. Sorry, that was a quick way to go over some of the legal standing issues raised by the developer in their submission. We did address it in the letter, but I wanted to hit it really quick in plain language for you. Now, on to the merits of this appeal. At issue in this appeal is Town Code Section 250-6.3b2, which we've been referring to in our submissions as the conflict clause. It's always nice to have a nice nickname for a clause you're referring to. The ZBA's task tonight is to determine whether the conflicts clause applies only to overlay regulations applicable in all districts, or to district-specific rules for what uses are permitted in each district that is subject to the overlay district. It applies only to the former. The language of the code is instructive. The conflict clause is located in a subsection entitled Overlay Regulations, a subsection that applies across all districts subject to that overlay, and that's in 250-6.3b. Now, by contrast, the district-specific rules about what uses are permitted are in the limited business district. The district-specific rules about what uses are permitted in the limited business district that is subject to the TFOD is located in a different subsection of the zoning code, section 250-6.3d, which specifies a different set of permitted uses than what are allowed in the limited district that is not subject to the TFOD. Applying the conflict clause to this section would render Section 250-6.3D meaningless, because it would almost always result in a conflict and allow an applicant to bypass the overlay district requirements, which could never have been the intent of the town board when it enacted the overlay district. It would make no sense to create a district that has superimposed requirements, and then to say that when you apply those superimposed requirements, there's a conflict and it can be waived. It also kind of impinges on your authority as the ZBA to grant use variances. So it's a very odd provision, but clearly could not have been designed to be used in this manner. Instead, it's much more appropriate to apply this clause to the portions of the section that apply to all districts, where you're less likely to have conflicts every single time, such as Section 250-6.3B, F, and G. Interpreting it in this manner would give effect to each provision and not render any part of the code meaningless. Now, the interpretation that I'm proposing is corroborated by other parts of the code. For example, Town Code 250-5.6 C1E provides, no conditional use permit shall or may be issued with respect to any explicitly prohibited use. That's really important here. Town Code 250-3.1 provides that any use not specifically set forth as permitted shall be expressly prohibited. So then we turn to the overlay district that's applicable here, the TFOD, and we can see that the takeout restaurant use is not listed as permitted when located in an LB that is subject to the TFOD. What that means is that takeout restaurant use is expressly prohibited under the town code in that district, and therefore a conditional use permit may not be granted with respect to that explicitly prohibited use where the LB is subject to the TFOD. One more area of law that I want to quickly touch on is a second error in the interpretation. The interpretation was that this code conflict clause allows the town to determine permitted uses for properties within the TFOD overlay district if the TFOD has different use regulations than the underlying zoning district. It does not do that. Contrary to the interpretation, Section 250-6.3B does not allow the town to determine permitted uses. I'll say it again. It does not allow the town to determine permitted uses where a conflict is found. Rather, it requires the provisions of the district that provides the greater safety protection shall govern. So there's no exercise of discretion there. If a conflict is found, which there's no conflict here, then the provisions of the district that provide the greater protections govern. It is not that a project, if it provides greater protection, governs. It uses the word district, not project. And so when the zoning interpretation substituted the word project for district, they committed an error of law. They essentially changed the code and then interpreted it based on that changed language. You can't do that. So those are some of the big merits of the legal issues. And then I want to quickly go on to some of the incorrect legal arguments raised by the developer in their submission. So no deference is owed to Carrie Ivor's determination, nor to any past precedent that was legally incorrect. So that means that you don't need to defer to the administrative determination of Ms. Ivors, nor do you need to be bound by a prior ZBA determination that you find to be legally inaccurate. The overarching principle in New York state law is that zoning boards are not bound to perpetuate a prior error. In fact, they may change their views when justified by rational explanations or factual distinctions. Courts have consistently upheld the ZBA's decisions when they correct prior mistakes or distinguish prior cases, even when it's inconsistent with past precedent. Substantive differences in application should be treated differently. Accordingly, you do not need to follow the incorrect past ZBA precedent cited in the developer's submissions, so long as you explain how the prior determinations were incorrect or factually distinguished. And I've laid the roadmap for you to do just that with my submissions. Likewise, the ZBA may not defer to Ms. Ivors' determination because as a matter of law, your review is de novo, which means that you're not deferring at all to the lower decision. The New York State Town Law 267B expressly provides that on appeal, the ZBA, quote, shall make such order, requirement, decision, interpretation, or determination as in its opinion ought to have been made in the matter by the administrative official charged with the enforcement of such ordinance or local law. And to that end shall have all the powers of the administrative official from whose order, requirement, decision, interpretation, or determination the appeal is taken. All that is just to say that you can make any determination that Ms. Ivers could have made, and you owe her no deference. For these reasons, the ZBA appeal should be granted. Carrie Ivers' March 14th zoning interpretation should be annulled, and the ZBA should uphold the plain language and obvious meaning of the code, which the town board enacted for a reason. And in doing so, require the project to go through the ordinary use variance process like anybody else without special treatment, because the proposed takeout restaurant use is clearly prohibited in the LB district subject to the TFOD. At this point, I trust that my other arguments are included in our papers, and I will entertain any questions from the board, any way that I can help you understand the issues or the legal questions involved. I'd be happy to answer.
I just want to give you the opportunity, I know you did last time, but do you want to comment at all on the original application for variances and sign permit? Again, we're combining all of them. You did before. I'm not saying you have to, but want you to let you know that you can do that if you like.
I appreciate the offer, Mr. Chairman, and out of an abundance of respect for the ZBA's time, I don't want to repeat any arguments that I've already made. They are more than covered in my prior submissions, which I've also incorporated by reference via these two letters into both sets of applications. And for clarity, I request that my comments with respect to this application be incorporated into the application on the underlying application.
Okay, yes, that will happen. So I would like to ask you to go over again the argument about the conflict and the district versus the project.
Yes, absolutely.
If you don't mind.
Yeah.
I'll try to focus this time even harder, because it's an interesting argument.
Thank you. Yeah, the town code is quite clear in 250-6.3B. Oh, I can give you a second to pull that up, because I see they're doing it while we speak. I'm sure it'll be an asset to the board to have that in front of them.
Yeah.
All right, there it is. So it says, the provisions of the district that provides the greater safety protection for pedestrian or vehicle traffic shall govern. That's in the B2, if you're looking for it.
Yeah, and we have it in the papers too,
Yeah.
but it is nice to see it on the screen.
So what that means is, and I argue that there is no conflict for the
Right.
first half of the, my argument earlier, but if you were to find a conflict, the correct response is not to then say, well, the uses that are authorized in the TFOD are thrown out the window. That's not what it is. It's that the provisions of the district that provide the greater safety shall govern. So when Ms. Ivers found a conflict and she said she's going to look at whether the project proposed will provide greater safety compared to existing conditions, that's completely different from comparing the provisions of the district to another district. And
So let me interrupt you there. So the provisions of the district that could you make that a figure again? Oh, there you go, for my old eyes. The
great.
provisions of the district that provides the greater safety protection of pedestrian or vehicular traffic shall govern. Isn't it understood there that shall govern a particular project application? I mean, doesn't there have to be a project for the analysis of a conflict to be made?
Even if you add those extra words, it's about the provisions of the district that provide the protections, not the project or the use of the property that provides the greatest protections. That's just not what the code says.
Okay.
So if the town board had wanted the ZBA in a case of a conflict to compare the effects of the project against the existing conditions of the property, it is certainly would have said so.
Yeah, I hear what you're saying. I'm just kind of struggling with, you wouldn't even get to the issue of a conflict unless a project existed. So logically, it's about the application of the provisions of a district to a particular project that is the subject here.
But you choose between the provisions of one district or the other, is what the code says, not between the effects of one project or the effects of one land use versus another land use.
Yeah.
It doesn't say that.
Okay, you've made it clear to me, and I appreciate that.
Thank you, Mr. Chairman.
Does anybody else have any questions of council?
I guess one thing that I'm a little confused of, specifically, like when you look at the, I think you wrote in the, and talked about the standing piece.
Yes.
It says, I guess, what are the specific harms that are specific to the applicants and not the general public? I guess, because that's one of the things that I struggle with, because if we're saying increased traffic, we're saying it impacts your group, sorry for saying your group, but your clients, but not the general public?
No.
Or, so I guess that's the part where I struggle from, because I understood when I read that it has to be specific to the people listed there, but it has to also not also impact the general public the same way. So if it impacts the general public the same way it impacts your clients, it's not applicable, I guess, is the way I read it. And that's, I'm just trying to figure out if, because I saw increased traffic, worsen congestion, safety concerns, and I felt like as I read that, it's like, how is that not impacting the whole public that drives through there every day?
Yep.
And specifically, the harm is to your clients and not everybody else. Because that's what I felt like we're trying to show. It's them and not everybody.
So that's a great question. It goes right to the legal issue, which is, so when people are closer, you have, first of all, the presumption that they're standing, and that's because, and this is going to sound so obvious when I say it, and I don't mean it that way, but people that are closer to projects suffer impacts greater than people that are further from projects. So
as property owners.
As property owner.
Okay.
And so that's one issue, and that in and of itself is enough to confer standing. But another issue that is alleged in our papers, and which I raised, is that members of our group use and enjoy the adjacent parkland and use it for both recreational aesthetic purposes.
But how's that different than the I guess that's the thing I keep going. That's a public park, or in a sense, how's that impact your clients more than the public? So I mean, I guess that's everything I was reading about standing, is I was trying to research this enough, and not having a legal background besides my business law class I took in college. I kept going back saying, how's this the harm to your group specific and not the public? Because that's what I kept reading, is it has to be, the injury has to be a legally protected injury to your clients, but not in general to the public. And that's what I keep trying to get around, is where is that differentiation?
Absolutely. And so the courts have found that where people allege that they use and enjoy a particular piece of land, and where it's parkland, it's even a greater one, where they're doing that, they do have an interest in that's different than the public, because the public generally doesn't use and enjoy the park for recreational aesthetic purposes. Specific people do. And we've identified our group members as those specific people who use and enjoy the park on a regular basis, and that recreational and aesthetic injury are the types of injuries that can confer standing.
And then the harm that so if this is built, there's harm that's suffered, what harm comes from a business going in there? I guess, like any general
Right.
business could go in there that was a sit-down, or, there's Dunkin' Donuts or Starbucks, like
Yeah.
any of those other ones. I guess, how's that
More harm.
more harm? I guess that's what I'm struggling with right now.
Right. So if you look at like the proposal, the multi-lane, 2 to 3 lane drive-through is going to be directly up against the boundary between this property and the park. And there are trails that go through there. And our clients have also alleged that they use this. And I don't think it's any stretch at all to say that where you have lots of exhaust and cars like queuing up, and that when you need 2 to 3 lanes for drive-through queues, and we know when we've seen all across the country, these are some of the most traffic-generating uses for fast food that you can find, that there's a reasonable concern that the park users in our group who use it for recreational aesthetic purposes will be adversely impacted in their use of the park and those trails by things like exhaust, fumes, noises, traffic going to and from, to the extent that it impacts entrances or accessibility to the park. Not just, and obviously, of course, in addition to the people who live within a mile who are affected in the traffic and other, ways that I've identified in ways that are greater than people that are further away. And so all of those things, the aesthetic and recreational impacts, the people who live really close by, those are different than the public at large who don't live as close, who don't use it in the same way. And so that in my, and I've had cases as well where I represent a group that, that uses a trail, not even a park, just a trail. And the proposed project was going to impact the trail. And, the court found, yeah, you have standing. It's a low bar for standing. It's a low bar. Yeah, you have standing because of both the proximity and because of the recreational and aesthetic uses. So I hope that answers your question, but I'd be happy to address any further if there are nuances that you'd like to explore.
Let me think about it for a second, see if that, just give me a second here, and someone else might have something.
In the same statement, you had also said that it would be out of place in the proposed area, that was one of the harmful impacts of this. If you could just elaborate a little bit more on what you meant by out of place, given you mentioned there is a Starbucks, there's queuing with Starbucks, there's queuing with Dunkin' Donuts drive-through. Those are all in sort of that same area. You have Five Guys, you have other kind of these restaurant-type businesses.
So the way that the code is set up, if you look at the zoning map, is actually really interesting, and it seems, in my view, very intentional, which is that as you're moving, let me orient, south to north on that side of the street, you're going from denser uses being authorized under the zoning code to less dense, less intensive uses. And the overlay district is used to further restrict the intensity and density of the uses there for a reason, right? Because as you go north, this is great. The colors do really some justice here. Adding the overlays will help too, because you'll see even more of the distinction. See, as you go up, you have the red, you have the yellow with the dashed lines, and you have the yellow without the dashed lines, and you have the pink. It's intentionally going from more dense, more intensive to less dense, less intensive. And so by adding an even more intensive use closer to the residential areas where it's supposed to be getting less dense, you have something that's really out of place, especially where the impacts of Chick-Fil-A are likely to be much more significant in terms of traffic, drive-through exhaust, standing vehicles than some of the less dense drive-throughs that maybe have only one lane. And we've also addressed some of the impacts associated with that in the area variance application materials that we submitted. Wow, that must have been end of last year, beginning of this year, which are incorporated as well. Does that help address the question about how?
I think I understand what you're trying to, yeah.
Yeah, okay.
I've got one question, but I'm going to direct it to Andy real quick.
Sure.
On that map there, you've got yellow. There's 2 parcels to the north of the applicant's parcel here that aren't dashed. Does that mean, in theory, they could have non-sit-down, a bit like, so the Chick-fil-A could go in there and they wouldn't be impacted by the overlay district, but they'd be closer to the residential?
Well, they're not within the overlay district.
Okay,
So
So if they went north one, in theory, they'd be closer to the residential, but they would not fall under the overlay district if they happen to be the parcel closer. So that,
Correct.
okay. It's kind of weird they did the buffer like that.
That is weird. I have not prepared any comments on what would happen.
I just saw that now, and I'm like, I wonder why that doesn't go up to the residents, the residential zone of red there.
Is that the same LV? 'Cause I see-
This is business right
Or,
here.
sorry, business, yeah. But in theory, less intense as it goes higher.
So I see that it's LB there written on top of the district.
That's the whole yellow area, yeah.
Is it also the part above it? Mm-hmm. Okay.
And then the overlay district made that hash stopping at the gymnastics training center parcel.
Yeah, and so another reason that it's out of place, you can see that the overlay district is applied right next to the park area. So what they're trying to do there is they're trying to have less intensive, less dense uses right up against a public park where people are going to be outside using the area and would likely be adversely impacted by having really intense uses there, which is why you have overlays to further limit that. Did I see another question over on this side?
Yes, so we focused a lot on your second point. I'd like to, could you summarize your first point for us a little bit more?
Yes. I'm going to try to say it differently so that because if you didn't get it the way I said it the first time, I'm not going to say it that way again.
Understood.
So essentially what's going on here is you have something that says that there's that you have a conflict clause, okay? And the conflict clause could either relate to a number of different things, right? So the question here is, what regulations does it apply to? And
Let me interrupt you for a minute. You said his first point.
Yes.
His first point related to standing.
Yeah,
Is that
to
what you
stand,
want? Yeah.
to standing,
you
correct.
want, I'm sorry, I thought you meant on the merits.
Yeah, I was just getting ready to stop him, but I didn't want to be
Rude like I was?
Yeah.
No, that helps. I appreciate
It's better to stop so he doesn't have to keep going on, repeat himself again, yeah.
So you had asked about standing. What was the specific question about it? Do you want me
Well,
to?
so the way you structured it, you said that this is actually the important point, and this second section is not really relevant because the first one would override that. I'm trying to understand how you came to that conclusion.
The first part.
In other words, the first part of your argument said that the resource that actually made the determination, we made it under false pretenses, or didn't have standing in order to make that determination. So I just want to be clear that maybe I misunderstood that.
You mean the Carrie Ivers
Yes.
determination?
Yeah.
I think what we're talking about standing is the standing of Preserve Penfield to bring the ZBA appeal.
Yeah, exactly. That's that. I wanted to be just walk me through that first point again.
Yeah. So standing refers to the.
You don't need to define standing. You need to define how you came to determine that standing wasn't met, that the criteria wasn't met.
I think we're using the word standing differently. I'm using it to refer to Preserve Penfield does have standing to bring the appeal. I think we're talking. Are you?
No, I'm saying I'm agreeing with what you just said. What I'm saying is that you made the determination that you tied back. You know what? Go ahead. He may answer the question through other. I'm not entirely clear on the determination from your right to make the appeal. And the second point, which we've been discussing over the actual details, the question you asked. It's those 2 points tied together are still disjointed for me a little bit.
Okay, so I'll try to clarify. The zoning code confers standing in two ways. Either if someone is aggrieved or if they're interested. We are both. Aggrieved and interested.
Got it. And that was, I'm saying, that connection wasn't made for me. You talked to them still separately, but you didn't connect the two.
Okay, I'm sorry. It's a curse of knowledge issue sometimes, so I appreciate you nailing that down for me. I really do.
Yeah, and apologies, I didn't ask the question in such a way you could get right to the point, so I got it now.
No, we got there together. Thank you. Yeah. So essentially, because they're aggrieved in the way that we discussed, which is, the effects of the projects, the aesthetic and recreational impacts, those are aggrievements, and also their interest in the application. The town code has made a determination that interest can confer standing as well.
Correct. Yep, I got it now.
Okay. Thank you for bearing with me on that one.
And then I got another one for you. I read another thing when I was looking at the whole standing thing, I keep going back to this, that for it to have, I guess, teeth to hold on to it, or, to mean something, it has to be a legally protected, there has to be a legally protected, in a sense, harm. Like for instance, if your neighbor bulldozes over your house or something like something that was, that was protected, your property was protected. I guess I need the jump to make the link there between the two of what are the legally protected things that are being harmed by, the exhaust in the park. I guess what's the legally, the legal aspect of what is being harmed, or what's the, since it has to be a legally protected interest, what are those? Because that's, for some reason, this still isn't, it's not syncing up for me in terms of what the, I realize that, there's increased traffic because there's something new is going to go there. So there's obviously going to be more traffic. I think there's no argument with that. There's some kind of traffic's going to go there no matter what business. The Gymnastics Training Center had traffic when it was there between, basically 3 and 7. It was really busy, 60, 70 kids coming in and out. But traffic doesn't, in my mind, seem like a legally protected, or there, how do you get harmed by that? And what's the grounds that if you went to court saying, I'm going to fight traffic, would they laugh at you? That's why I'm not sure.
I understand the question. Yeah,
okay,
it's a good question. The standard is whether it's within the zone of interests to be protected by the statute. So that's the question is, and I think once we say it this way, it'll be really clear, which is things like traffic, congestion, safety, impacts on the neighborhood and parkland, compliance with the code, the zoning code, and the laws that we have here that we're addressing. Those laws intend to protect these interests.
Got it. Okay, that makes sense.
Yeah. Same with things like the protection of, recreational or aesthetic interests.
Okay.
Yep. That just helped me make the connection too. Yep, thank you.
Absolutely, yes, thank you, yeah. So the zone of interest, just that the zoning code is intended to protect against these types of adverse impacts.
All right. Any other questions for council?
Not
No, sir.
All right.
I want to thank the ZBA for the excellent questions and engagement on the issues. It's really refreshing. Thank you.
Oh, geez, thank you. We have Chick-fil-A reps here, so why don't we call you folks up and have you chime in on this, and then we'll go around the room.
Thank you, Mr. Chair. Am I on?
Yes?
Thank you, Mr. Chair. My name is Rob Stout. I'm a partner at the law firm of Whiteman, Osterman, and Hanna in Albany, New York, representing Chick-fil-A on the underlying application and also defending against this appeal. I'll defer largely to our papers. I don't want to take up this board's time any more than we have to this evening, but I will address the points that were raised by counsel for appellant and also answer any questions that this board might have, and I'll try to address the questions that you've raised in the context of the proceedings so far this evening. First, on the standing issue, it's the threshold issue. I actually agree with counsel that proximity can lead to a presumption of there being an impact, but not the proximity that we're talking about here relative to the members of Preserve Penfield that were identified in counsel's letter of July 11th. I looked at the distances involved for those residences. Most of them are at a considerable distance. Council indicated some are within a mile. It appeared to me that the closest residence was approximately 1,900 feet, perhaps a little bit more away. I was trying to make every inference in favor of finding the closest properties. So there are cases out there that reference properties close by to projects being granted standing just by virtue of proximity. But those cases reference properties that are 200 feet away and in some instances 500 feet away, and those cases are cited in our papers, not 1,900 plus feet away. Once you get that far away, the potential impacts become more attenuated, and as this board has pointed out, those potential impacts start to look more like the impacts that everyone else in the community could face from the project. Now, we dispute the fact that those impacts are going to occur. In fact, as we'll talk about more as the evening goes on, we think we're actually ameliorating the traffic conditions on the road and improving the situation there. Notwithstanding that, even if you assume that there will be impacts, they are not of the kind that might be faced by these appellants individually that the residents of the town wouldn't otherwise suffer. Importantly, while Preserve Penfield and its members have a right to be heard at the public hearing on these matters, and in fact should be heard and participate in this process pursuant to all of the notice provisions you reviewed at the beginning of the evening, the right to bring an appeal under New York law is constrained. This is a quasi-judicial body. Courts aren't available to everyone who might or might not have a dispute. There needs to be an underlying potential impact in order to adjudicate. Our papers review how that ability is limited to those who have sustained special damage different in kind and degree from the community generally, and they must have sustained an injury and/or have a legally cognizable interest in the matter being appealed different than the general community. Reference was made to the impacts being or parties who are interested in a matter being conferred standing. Frankly, I would venture that anyone who is interested in enough to come to a public meeting and comment on a matter has some degree of interest in the matter, and it's just inconsistent with New York state law to assume that everyone who's interested in a matter and who might comment on that matter also has standing to bring a challenge on that matter. That would render the principle of standing pointless at that point. Reference was also made to the fact that the Preserve Penfield members may use the park, and that use of the park could also give rise to standing. Again, use of the park is available to all the members in the community. It's not something that is exclusively used by the members of Preserve Penfield or anyone else bringing an appeal. The council did cite a case in his papers for that proposition. Committee to Preserve Brighton Beach and Manhattan Beach, Inc., v. the Planning Commission of the City of New York. The underlying facts in that case suggest that while standing was found, the underlying decision was to grant a concession for construction at the park. So that was something that was happening at the park. Our project is not at the park. It's adjacent to the park, but it's not at the park, which I think is a key distinguishing factor from that case. Don't believe I have anything further on standing unless this board has any questions for me.
I do have a question on that. You know, on the use of the word interest, which is interesting. I take your argument to be that use of the word, well, the words aggrieved or interested does not change the test that New York courts have developed and used to address the issue of standing.
Well, the authority that the board derives its authority from New York Town Law 267A4, which sets forth the standard that's been interpreted by courts, and that's that such appeal may be taken by any person aggrieved or by any officer, department, board, or bureau of the town. So to suggest that the jurisdiction can be expanded is inconsistent with the case law that we've reviewed.
Right, that's what I was asking. So, okay, I understand your position. Can I ask you, the 1,900 foot, do you know which named individual that was, and how did you measure that?
I don't know the name of the individual. It's frankly unscientific, I'll admit. It's 55 Random Knolls Drive. This is a Google Earth image where we drew a line as the crow flies to the nearest corners of the property, and it yielded a measurement of 1,916 feet. I assume that the actual measurement is plus or minus that. I wanted to illustrate that it was materially in excess of 500 feet, which are the cases that we see
Yeah.
granting automatic standing.
So if I may interrupt you, going from council's letter, it looks like the person that lived, 55 Random Knolls, you said? Is that what you-
Yes, I'm sorry, 55 random names.
Michael, is that you? Are you 1,900 feet? Is that, would you agree with? Why don't you come up, because I'm going to yell at for not asking you to use the mic. And I'm sorry to interrupt you, but I want to address that particular point at this
Fair point.
moment. Go ahead and sit down and give us your name, and then you can come back later, but at this point, I'd like you to answer the question, do you agree with council's estimate of how far you are?
So my name is Michael Krejcik. I live at 55 Random Knolls Drive, which is just off the corner where Wayland crosses 250. And I go through that intersection of 250 and 441 at least once a day, if not multiple times a day.
Yeah, like I said, you'll have a chance to come up and talk about the harm. But one specific question now. Do you agree with, even close to his estimate, that you live approximately 1,900 feet away? Because honestly, it seems to me to be way more than that, but maybe I'm wrong. So you're the guy that lives there, and Andy, I don't know if you can do an unscientific measurement now. I just want to, whatever folks here can kind of estimate is a fair number, let's get that out there.
I thought Andy provided us the distances. Wasn't that in one of the?
No, it's, so, I mean, I don't know if it's.
I don't know the answer to that. I mean, I
Okay.
can do it on Google Maps.
That's fine.
It doesn't take me more than 30 seconds to get from my house to that intersection.
All right, I got it. I just, that's fine. All right, I appreciate you coming up to answer that, and go ahead.
And respectfully, I do understand that, but that is the intersection that everyone else in the community would use. My point was limited to the concept of automatic standing being
No,
conferred.
and that's why I think the number is, and council will probably both agree with it, that the number is certainly relevant, so I wanted to address that point before we forgot about it.
I have a follow-up question to that.
Okay?
Andy, how far of a distance do we send postcards? In other words, how far does the town say we're going to notify somebody we believe will be impacted? And how was that determination made, do we know?
It's dependent on a couple things. The size of the parcel or the project. Typically, it's, is it 500 feet?
I want to say it's 1750 for this one.
1750 we went for this one. So anything within 1,750 feet received a mailing, a postcard.
And do we know how they determine that distance?
It's measured from the project.
No.
The site?
Why those distances were chosen? Was it based on precedent on law, or was it an arbitrary number?
That I'm not sure. I mean, it is something that the town board established, I believe.
I think it's
that's
normally like
correct.
500 feet. Normally they are. For most applications, it's 500 feet-ish.
It
For
depends on the acreage.
Yeah.
1 to 5 acres is like 500 feet, 5 to 10 is 7, well, then there's 750, then 1,200, then 1,750.
So I'm asking the question because it seems to me that the town has established that's the distance by which they believe people would be impacted by any given request for exemption or project or.
Yes, and I
Okay.
understand that was like years ago that the town board did that. There hasn't been any updates.
Yep, understood.
By the way, this is, it has been Christine Shaw talking here for the record, but when you said it depends on the acreage of what? The subject property?
Correct, the application, yes.
Okay, thank you. All right, go ahead, counsel.
Thank you. I'll move on to address what is being referred to as the conflict clause. This board is aware the property is located in the LB zoning district and the Route 250-441 overlay TFOD zoning district. Takeout restaurants are permitted via conditional use permit in the LB. The enumerated permitted uses in the TFOD include sit-down restaurants, but not takeout restaurants, and this is what gives rise to the conflict that we've been talking about. Section 250-6.3A sets forth the purpose of the TFOD, which includes recognizing the unique nature of the area of the town, which is the only area in the town to be located at the intersection of two heavily traveled New York State arterials. This area is impacted by rapid growth in the adjacent communities both to the south and the east of the area. The area is not currently served by any interstate highway, as are other commercial zoning districts in the town. The primary intent in creating the 441-250 overlay district is to preserve the character of those residential properties surrounding commercial uses, enhance accessibility and convenience to commercial uses, lessen traffic congestion, and promote greater pedestrian and vehicular safety in the area. These objectives will be accomplished through coordinated access management and ensuring that commercial development remains localized in nature and is scaled to primarily service and support the needs of the residential areas surrounding it. This overlay district is further designed to safely manage those existing commercial developments as well as a significant number of undeveloped commercial properties through improved traffic flow and more efficient use of available land with shared access and parking areas compatible with and not detrimental to surrounding residential properties. So the question becomes, how do we effectuate those goals? How do we do that in this overlay district? Well, the regulations inclusive of certain permitted uses follow in this section, which are in some measure different than the underlying zoning district, the LB zoning district, within which it sits. The town board, when adopting the TFOD, wisely did not want to do anything that would inadvertently interfere with the goals that I just mentioned. So flexibility was included. The language provides, in the case of a conflict between regulations contained in the underlying zoning district and the regulations contained in this overlay district, the provisions of the district that provide the greater safety protection for pedestrian or vehicular traffic shall govern. So here, we're proposing a use permitted in the LB, and by the way, consistent with the character of the neighborhood, which inherently provides greater pedestrian and vehicular safety, hence the determination that was issued by the building department. So I asking myself the same questions that the board was asking of the appellant's attorney, and frankly, I think it's strained to read that conflict cause language to only apply to section 256.3B, the overlay regulations, which read as if they are aspirational and directional in terms of the goals that are established. Reading on, the section becomes more specific. It gets into the specific use regulations that are allowed in the area that is underlaid by the LB district. Therefore, it seems reasonable and appropriate for the building department to have concluded that given the nature of the project, given the nature of the underlying use, which is permitted in the LB, this was an appropriate instance to conclude that the purposes of vehicular safety, along with the other purposes of the TFOD zoning district, were served by allowing the project to move ahead.
Okay. Any questions of council?
Specifically, your project would bring greater traffic safety because?
That's a tough left-hand turn coming out of there. There's going to be a signalized intersection where one does not exist, that put up by the applicant at no cost to the town. There's, as everyone knows, there's a series of internal roads which connect those developments on that side of the road. Right now, none of them are signalized, so this will have the effect of appropriately channeling traffic to a signalized controlled intersection, eliminating that left-hand turn. We have our traffic engineer here who can get into greater detail. don't take our word for it. The town hired its own independent traffic consultant, which affirmed those conclusions and confirmed that the project will have a net impact on safety. DOT has concurred, and it will also serve the properties on the other side of the road as well.
Thank you.
All right, any other questions for council? I'll ask you the same question that I asked council for the applicant at this point. Do you wish to address any of the issues regarding the original application, as we're taking all of them at once and that public hearing is still open, knowing that your partner addressed them thoroughly at the first application?
I don't have anything specific to address. If you'd like our engineer to provide a summary of what those, what the variance relief is, I could ask him to do so.
Anybody want to hear that? No? Okay.
I have nothing to add. Nothing's changed.
Right. Okay. Great. Thank you.
Thank you, sir.
So a number of people have signed up to speak, but I didn't keep them in any particular order. So what I will ask is there anybody that signed up that kind of needs to get out of here and wants to go first, or do we not care? Don't be shy. If you need to, raise your hand if you need or really want to go first. Okay, maybe I'll mix them up and just call them in that order. Let's do that.
Now they have no one to blame but themselves. You did give them the opportunity, so.
So the first name, Nancy Catarasano? Close? Catarasano. All right, great.
Good evening, I'm Nancy Catarasano. I live at 23 Balmoral Drive. It's less than 1.5 miles from the site. I've lived within 1.5 miles of this site for almost 45 years, so I've been in the Penfield community a long time, raised my children at Harris Hill and use that park all the time. So my point is, this is not about building something new from scratch. This is redevelopment. Taking a vacant, deteriorating building, transforming it into something that adds real value to this town. Right now, next to a park, that property sits empty, attracting vandalism, unsafe activity. This plan brings a respected business, significant private investment in our community, and a more attractive functional site. More importantly, the traffic light proposed as part of this project is a much-needed safety improvement. That intersection has had many accidents over the years. The fact Chick-Fil-A is willing to pay for a light and help fix a known problem in that area should not be overlooked. I believe this project makes sense for Penfield. It brings jobs, enhances safety, and revitalizes a blighted property that's such an eyesore. I respectfully urge you to support this. Thank you.
Okay, do we have any questions of this witness?
No.
Thank you.
Thank you.
All right. Guess who the next one was? Jacob Zoglin, but yeah, you already went, so.
20 seconds.
Oh, yeah, sure. I was kind of kidding you, but if,
I
yeah.
knew you were, but I couldn't pass the opportunity by.
All right.
So counsel for the developer referenced the fact that we don't exclusively use the intersection or the park or things like that. That's kind of a red herring because exclusive use is not needed for standing. You know, you don't have to be the only one that's ever been injured by something to have standing or to be affected or to appeal something or to bring a case. The issue about aggrieved in the state code and adding interested and aggrieved in the town code, you can view that in two different ways. You can view that as the town code creates two different lanes to get to standing, or you can view it as the town code broadens the definition of aggrieved to include interested, which is a fair interpretation as well, and therefore is aggrieved under both town code or the state law. And then third, they'd done a measurement from one of our members' properties, but we had also identified 23 Bramblewood, which is within 1 mile. And we had stated that on page 3 of our last submission. That is within a mile, so a much easier lift for standing purposes.
So within a mile can mean a lot of things. Is that, do you know that that's like the closest one of the ones you listed?
I don't know it's the closest. I know that it is closer than the one that was referenced before.
I thought it was the other way around, actually. I actually thought the one on Random Knolls was closer, but they're pretty close as the crow flies. They're pretty similar.
I haven't compared all of them, but I thought the thrust of the argument was it wasn't within a mile. This one is within a mile.
Yeah.
So I was just trying to put that to your attention. And that's on page 3 of our last submission. And then I wanted to, they mentioned a lot about the impacts of the project, and I wanted to refocus and reorient you on the district's, the provisions of the district that provides the greatest protections is what applies, not the land use or project. Thank you.
Gotcha. You're welcome.
For clarification, there are 5,280 feet in a mile. So I think that his 1,900 was actually in your favor.
Oh,
Well,
Just for clarification, you
Literally
might want to
Googled
just
the
stick
same
to your
thing.
guns on that one, yeah.
Just Google mile.
someone was paying attention in 6th
I
grade.
probably heard it as 19,000 is probably why I thought that.
Yeah,
I appreciate both ways then.
yep. Next person on the list, Karen Ihrig. 2016 Penfield Road.
That's right.
Okay, then you can launch right into your comments without having to repeat your name and address.
I just wanted to read the email that I sent to the zoning so people in the audience would hear it. It is with enthusiasm that my husband and I give our full support for the development of a Chick-Fil-A restaurant in the former gymnastic training center. For the past 40 years, we lived within 2 miles of the location and are, frequent travelers of that stretch of 250. The turn into and out of both plazas to access other quality businesses has always been cumbersome. Further, the vacant building becomes an eyesore and is prone to vandalism. With the traffic light addition, I think that is a much-needed area, so we fully support it. Thank you.
Hold on. Let me
Yep.
just- Are there any questions of this witness? All right, thank you.
Thank you.
Next, we have Don Palmieri. '23 Bramblewood Lane.
That address sounds familiar.
Yeah.
Yes, we talked about it. So yeah, I live at 23 Bramblewood Lane, and if there's any neighborhood that's really going to be impacted by this proposal, it's our neighborhood. The Bramblewood Lane address is very close to this proposal. And they're talking about a traffic signal that's going to improve everything. It's like a magical traffic signal. It's going to make this very safe. And the town did a study. In a 3-year period, there were 65 crashes that occurred on 250 and 441. And that intersection has multiple traffic signals with a dedicated turning lane. So I don't see how this magical traffic signal is going to, solve the traffic issues on 250. As a matter of fact, when I come out of Pembroke to 250, there's certain times of day that I just give up. I'm not even going to try to turn on the 250, especially turning left. That's not going to happen. There's just so much traffic. If I want to turn right, like to go to the Y, like after 7 o'clock or something, it's a possibility, but the traffic on 250 is just, my understanding is that there never really was a traffic study done for our neighborhood, and I don't know why that did not occur. And I've never got a postcard that this was going to be occurring, this hearing. We never got postcards for this. And I know the town has a comprehensive plan prohibiting, drive-throughs, and this does not, the proposal doesn't align with the comprehensive plan. I mean, it aligns with the incomprehensible plan, but it's not a comprehensive, not part of the comprehensive plan. Again, because of the proximity to the park, Penfield's biggest asset one of the Penfield's biggest assets are parks. And with the noise, idling vehicles, exhaust, the drive-through is just, it's too close to the park. And you're right, it's not just Preserve Penfield members, it's the whole community that uses that park for ball fields, for trail walking, walking dogs, tennis, multiple uses in that park, and it doesn't align with the town's plan here.
Okay.
Thank you.
Okay, well, let me ask, anybody
sure,
have any
sure.
questions?
Just one point of clarification. I was on the comprehensive planning board on the last comprehensive, and to be clear, the approach was to put the drive-throughs in appropriate places. It was not to eliminate them or not to allow them. So just to be clear.
Okay, so again, I don't understand how this is going to enhance the character of the community.
Yeah, no, just like I said, if when you make a comment, we want to make sure we're clear as to what the comprehensive planning board actually did state. So.
Okay, sure.
Thank you. All right, Mark Allen.
Good evening. My name is Mark Allen. I'm one of the owners of the former Gymnastics Training Center at 2051 Fairport 9 Mile Point Road, a property my partners and I purchased in November of 2022 with the hopes of restoring it, redeveloping it, and bringing a strong community-minded user. I grew up in Penfield. My family lived on Redwood Drive. My parents are here. My wife and my son are here. We later moved to a home in Pine Valley Circle, which I just realized is 5,808 feet from the proposed property. I was in Random Knolls a lot of my childhood, which I believe is about 3,696 feet from the proposed property.
Let me interrupt you, and then where do you come up with those numbers?
AI. But that's...
No, because you said you just realized, so
I just
obviously you
realized
must
it
have been
because I've
doing
never
something.
thought
Yeah,
through
okay.
that. But I think it is important.
Both council have said distance is important, so
I think,
keep asking
No,
it.
Chairman, I appreciate that
No,
question.
yeah.
To be clear, I have prepared remarks. I'll give them to all of you. Before diving in, I want to thank all of you on this zoning board, the planning board, your colleagues there, and the town board. Your time and commitment's impressive, and this process hasn't been easy with this application, and listening and watching applications over the last 2.5 years has been noticed and appreciated, so thank you. My partners and I are very proud to be working with Chick-Fil-A. After more than a year of planning, engineering, public input, we are seeking a few final variances tonight in responding to an appeal from a very devoted, small, important group here in Penfield, opposition group. To be candid, it's frustrating, though, how difficult it's been to advance this process. It's clearly a positive development for the town of Penfield. The site's long been commercial. As we all know, Sarah Jane Clifford had the Gymnastics Training Center for over 28 years. Hundreds of families utilized the site. The traffic was there, and we're trying to propose another high-quality user in Chick-fil-A. Obviously, there will be more traffic vis-a-vis where the project sits today as a vacant building. That's the goal of redevelopment, to bring energy, purpose, and life to a former use building, and this is certainly an underutilized property. We've said it enough, but Chick-fil-A is investing $1.5 million for a traffic light. Their focus is on safety, and this known crash pattern is critical. Obviously, on Monday, there was another accident. Thankfully, it wasn't tragic, but this is something that the town's endorsed, your engineers endorsed, the New York State Department of Transportation's endorsed. It's long overdue. Obviously, beyond safety, this project brings jobs, removes blight, and I think our residents in Penfield want that. I think this is personal. I grew up in Penfield. I went to elementary school at Harris Hill. Sledding, et cetera. I biked around the building a few weeks ago, and we cannot keep up as property owners with graffiti, vandalism, et cetera. Our friends at Preserve Penfield have called us out as property owners to not maintain the building. We cannot keep up. Painting, replacement of windows, security, et cetera. It's not sustainable. And also, as some of our adjacent neighbors and the Cipro family here with the Penfield Pub have had to call the police, it's actually very it's sad. It really is. Some have suggested that we're going to profit handsomely on this project. Again, Preserve Penfield's put that out. That's not entirely true at all. We've owned this thing for 2.5 years with no rental income. This is not about profit. This is about doing what's right for our town. Local businesses support the project. I want to just highlight that Chick-fil-A is already come in and supported Penfield, and they've shown up. They've been at the Little League Complex. They've been providing food for our first responders here in the town. They're not just saying they'll be good neighbors, that they are. A few more things. I've read and reread again the Preserve Penfield mission, which is to promote development that supports the town's long-term well-being and to push back on projects that exploit the town for private gain. That's not what we're doing. We're trying to restore a blighted and now unsafe site with a stable user that adds lasting value. I believe we share more common ground than it may seem. We also share Preserve Penfield's commitment to safer roads, strong local businesses, and thoughtful land use. I think this project delivers on all three. You have Chick-fil-A investing in the safety side with the light and the pedestrian crosswalk. The current gymnastics training center is a 23,000 square foot property. The Chick-fil-A site will be 6,000 square foot. You'll have 75% less visual on the building, which I would argue is going to improve the ecological and visual quality of this parcel and curb appeal. And on behalf of my partners, I do respectfully ask your approval. I'd like to move forward with this. Let's bring vibrancy back to this last corner and parcel of 250-441 and turn this, what I would call an eyesore currently, into a point of pride for our future as a community here in Penfield. And I appreciate all of your times. Any questions, I welcome them.
Okay, thank you very much.
I'll leave some hard copies for each of you here.
Okay. Next person who has signed up, Eileen Anderson.
Hello.
Hi.
I live at 50 Edenfield Road. I don't know how many feet away from Chick-fil-A, but it's my neighborhood, it's my community, it's places I go by bike, by walking, by car, and I'm impacted by this. And the idea that I or anyone in Preserve Penfield doesn't have standing in this concern surprises me. Chick-fil-A, if you go on the internet, has a zillion bad reviews for their structures, for the traffic, for the, that they don't address. And they said at the earlier meetings, they were still learning. After 3,000 stores, they squeezed this project into this site, and they're asking for a zillion variances to make it work. But we don't have to say yes to this. We don't have to give them concessions because it doesn't fit our zoning codes. And a traffic light that doesn't have another street on the other side is not going to address the traffic concerns on that area, because there's Pembroke Road, there's the plaza on the other side. I go to the medical center there. I have arthritis. I'm an old person, and I get my blood work done there. Do I want a zillion cars driving through there when I'm getting medical attention, especially at an orthopedic place, to make a cut through? It doesn't make any sense. And I don't know how everybody could have approved this traffic study on a road that is overused right now and bring in thousands and thousands of cars. There's no bike lanes on that road. You got to ride your bike on the sidewalk, which isn't a good idea. And the traffic light's not going to address that. The closeness to the park, it's not an asset to our town. It's not going to make Penfield better. It's just going to bring congestion and more accidents and, all the way up 250, all the way through to other complexes in Fairport that were never addressed in the traffic study. I don't think you even went as far as Wayland Road to look at the impacts. All I'm asking is that you look at this for what it is, a building that requires a lot of zoning changes and doesn't work in the spot. doesn't work, and one traffic light is not going to make it safer. I truly believe that, and I hope you look at it carefully. And I believe everybody in Preserve Penfield, in that neighborhood, has a standing in this because it affects us every single day. Thank you.
Any questions for this witness?
No.
All right, thank you. All right, next is Michael Krejcik. Come on back.
Come on down.
And 55 Random Knolls.
Yeah, 55 Random Knolls, just off the corner of Wayland and 250, and I've been there for in the neighborhood of 41 years. Let me start off with 2 points that I think are of great concern to just reinforce them. The lease for the Chick-Fil-A is for 30 years, as I recall. By definition, then, the decision that the Zoning Board of Appeals will make will have a generational impact on the residents of Penfield. Very roughly, according to the traffic study, roughly several thousand cars per day can go through the 441 and 250 intersections. According to the Town of Penfield traffic study, it's the second most dangerous a dangerous intersection in Penfield. The accident rate is far above what the New York State Department of Transportation estimates would expect. Next, I'd like to comment on a number of issues associated with the Chick-fil-A traffic study. Let me first start off and say that it was very professionally done. It's highly, there's a lot of analysis in there for what it was designed to address. But let me get into the issue. As an example of this issue, imagine you're the FAA trying to solve the air traffic congestion problem in the United States. You commission a study to be done, and the answer that they come back with is to add another air traffic control tower in Atlanta, the busiest airport in the United States. No analysis, or let me put it this way, no significant analysis was done for airports inside the United States, Chicago, Denver, Detroit, Dallas, or any West Coast airports. To solve the problem that the Chick-fil-A will introduce, they recommend a stoplight at the Don's original driveway. No other remedies were offered except requests for multiple zoning variations. Here's the problem with this. The traffic study was only for a few hours over a few days in March and April. This is not near enough to understand the hour-by-hour, day-by-day, week-by-week, and month-by-month variability in traffic that flows through that intersection. No incorporation of morning rush hour peaks was included, and since Chick-fil-A offers breakfast, this should have been looked at and needs to be looked at. No analysis of winter issues when snowstorms or other adverse conditions could reduce the flow of traffic and queuing on Route 250 to just one lane each way, or with the effect of other extreme conditions like rain or accidents. No detailed mathematical analysis of what's going on inside the plaza itself other than the use of a tool called Synchro, which I'll get to in a second, and again, the flow of traffic hour by hour, day by day, except for assumptions made for the Grease and Cicero Chick-fil-A's. The problem there is that those Chick-fil-A's have only 2 drive-thrus, not the 3 drive-through that the Penfield proposal has. The queuing analysis was done for traffic inside the plaza using a tool called Synchro. It's a deterministic tool. In other words, you put a number in, it puts a number out. It doesn't look at variability, the probabilistic distributions. It's not a simulation tool to look at active and dynamic queuing. No analysis was done looking at the impact of the proposed traffic light on other flows of Route 250. as other people have mentioned, people turning left out of Pembroke Drive or the post office or the RGH Health Center, the Penn Fair Plaza, the gas station on the corner, or the driveway where Monroe Muffler Shop and Starbucks is. The traffic light will cause people to slow down and queue up, which will definitely affect these flows. No incorporation of foot traffic and the effect that dining customers will have, and the customer ordering patterns and service time, and the workload will, this will cause delaying drive-through customers and hence the queue of car waiting. Since we use Google AI, according to Google AI, the average Chick-fil-A serves an average of 1,500 customers per day, with some estimates ranging as high as 1,900 to 2,200 customers per day, and can add additional 100 cars during peak hours. The 100-car figure entering and exiting is mentioned in the traffic study that was done. And in that traffic study, it also mentions that this figure could be over 200 cars in an hour, both entering and exiting the Saturday peak. So, what's the solution to this? Well, for 32 years, I built computer simulation models for Eastman Kodak. Anytime they would build a new factory, they would simulate that. They would simulate the flow of orders, how much storage, how much people, what's the scheduling of equipment and the scheduling of orders, what's the queuing that's going to build up. We also modeled emergency rooms. So we modeled people with different injuries, ambulances pulling up, cars pulling up and dropping off. How many doctors did we need? What's the queuing of beds? How long would people take before they got seen and before they finally left the facility? So those types of models were very similar to this particular situation. The flow of customers in Chick-fil-A has the same highly variable and time-varying nature of the inputs and time to service the customer as emergency rooms or other types of studies we've done. And the traffic study that's been done so far doesn't account for this highly variable nature. Therefore, a computer simulation needs to be done to answer the questions about how much parking, what is the impact of cars backing up, could traffic cause gridlock inside the plaza, what staffing levels are required to prevent backup and gridlock. By the way, the average Chick-fil-A employs 25 to 35 people. And those are going to take up the limited number of parking spaces that has already been proposed. Could traffic back up on Route 250? What happens in extreme conditions when the road narrows due to weather and accidents? What happens to the flow of traffic when other businesses want to turn left and are limited by the queuing up at the stoplight? A simulation can answer all these questions, and the newer tools are not only mathematically and logically correct, but they also are visually correct, because they could animate right on top. If you can pull up the layout of the facility, of the layout with the, So you could actually see a real live, mathematically and logically valid animation right on top of that drawing, show you the queues building up and what would really happen. In addition to charts and graphs and other types of statistical output. So why do we need this? Well, for one thing, the Chick-fil-A proposal asks for a number of code variances in terms of parking spaces, setback, green spaces. This is because the Chick-fil-A is bigger than any other round, having 3 drive-through lanes, and is too big for the space that code would allow. We deserve a robust, powerful mathematical analysis of what this impact is. Assumptions made by developers based on other Chick-fil-A's are simple numbers and are not enough given the generational impact of the proposal and the thousands of impact on Penfield residences per day. Is a detailed simulation killing a fly with an elephant gun? Who would build a simulation to help design a fast food restaurant? Well, Chick-fil-A would, and Chick-fil-A did. This is a simulation done by Chick-fil-A. Now, it's for a simpler situation. It's basically a mall-based Chick-fil-A, and the analysis they wanted to do was what's the staffing level they required. And it doesn't use the degree of complexity of a tool which is needed for this particular problem. The point is that fast food restaurants, including Chick-fil-A and Burger King and McDonald's and others, use these tools for all sorts of design problems. Simulations are widely used in the fast food industry to look at changes and improvements. As I mentioned, the traffic study is highly detailed and very professional, but it's just that, a traffic study designed to look at the flow on Route 250 and make recommendations about how to solve the problem going in and out of Don's Original or the Penfield pub. It isn't a robust mathematical analysis taking into account the highly variable number and types of customers and time-varying nature of the flow into and out of the plaza and the surrounding areas, the post office, Penn Fair Plaza, et cetera, et cetera. Much more data needs to be gathered and a model built to adequately represent what's really going on. The town of Penfield deserves a computer simulation study. There are many tools and companies out there, tools such as Arena, ProModel, Witness, that could do this. RIT actually teaches a course on computer simulation and has people that are available that could do these kinds of studies. Given the numbers of people affected and in the town of Penfield, the developer needs to do one of these to ensure their program is sound. Instead of being an imposition to developer, this should be viewed by them as a win. It's a chance to prove their concept. The other thing that I would offer up is I've heard a number of statements about how the traffic light will improve safety, and it's a good thing to be doing. Well, if it is, then let's do it now. What's the holdup of putting that traffic light in right now and seeing what impact it'll have to help things out? Thank you for listening to me.
Any questions of this witness?
No.
All right, thank you, sir. Okay, the last slip I have in any event, two people, Karen and John Cipro.
Hello.
Hi.
John and Karen Cipro. We live at 82 Eaglesfield Way in Fairport, and we own and operate Penfield Pub, formerly Don's Original, and we are not against Chick-fil-A coming. We actually think they'd be a great neighbor for us, and but we do have some concerns. A lot of what the gentleman just said before us.
One of my concerns is the light itself. If you could bring up the light put out there, I had asked years ago, after seeing accident after accident, if a light could be put there, and the then town supervisor, George Wiedemer, told me it wasn't possible. It's a state road. They will not allow it because there's one slated to go in at Pembroke, and it's too close. Now, has the state okayed a light to go in there? Was this a financial reason the light couldn't go in there, or is it too close, and will it never happen?
You talking about the Pembroke light?
That light, will that light actually go in? Has the state actually said it can go in?
My understanding is yes. I don't know the reason why the state said no in times in the past. But Andy, you want to elucidate on that in terms of, has the state committed to putting a traffic light if this application is approved?
I believe they have.
Believe is one thing.
Well, that's a fair statement. You want to come up, identify yourself, and answer the question? Thank you.
My name is Amy Dake. I'm the Senior Managing Traffic Engineer with Passero Associates representing Chick-fil-A.
Could you speak up, please?
Oh, sorry. Is that on? Can you hear me?
It is on, but
Okay.
speak up as well. Folks are raising their hands
Sure.
and such.
The state did, in fact, review the traffic impact study, and they issued a letter that they were in agreement with the conclusions of the traffic study, all of the methodology and analysis contained therein, and they did agree that a traffic signal is warranted, necessary, and that they will approve it. They have approved it at this location. So all that's left now is to submit design plans and get their approval. Chick-fil-A will be paying for the installation of the signal. The reasons why it was not put in the past is because there are several thresholds that are required when a traffic signal is proposed, and many of those thresholds were not met previously at the existing driveway. It has to do with the volume of traffic that's exiting, and because it's so difficult to make that left turn, the volume of traffic is on the lower side right now, but with the addition of the Chick-fil-A, it does now meet the thresholds.
Okay, well, that's good news.
Thank you.
Our problem is being directly next to the Chick-fil-A. We are probably the most impacted by it going in. Traffic coming from the north, traffic coming from the south, we're right smack in the middle. Will our customers be able to even get to us? How long will they have to wait in a line to get to us, especially during the initial buzz, which I've read can be several weeks to a couple months. Several weeks to a couple months of our customers not being able to get to our restaurant can make a significant impact in our restaurant. We're not against it in the long run. We just hope to find a better solution for people to be able to also get to our restaurant, an extra access road, or maybe if they're coming in at that light, they can only go into Chick-fil-A, and other people have to come in the access road. And if they come in the access road, they cannot get to Chick-fil-A. So the traffic isn't even clogged up on the access road trying to get to Chick-fil-A. I can just see people coming from every direction trying to get to Chick-fil-A, and they can't get to us. So that's my biggest fear. Maybe I know that the lot to the north of this parcel is available and somewhat secured by the owners of this building, and maybe a light can go in at Pembroke. They could have that extra lot for additional parking, and that will alleviate their parking problem because, as it was said, they have up to 35 employees. They only have, from what I understand, 101 parking places. And it'll alleviate, if it gives them more room to loop around, it'll alleviate flow over traffic from being on 441. Maybe that's a solution. I don't know. If there's only one way in to Chick-fil-A and one way out of Chick-fil-A rather than everybody else's way in and everybody else's way out. We've been in business there 20 years. We've lived in Penfield up until this year. For 30 years, our kids went to Penfield School. I want the development of Penfield. I want to see that eyesore of a building gone, but I also have to protect our business and make sure that our business is not going to be squashed out by another big business. Mom and pop. We're mom and pop owning and operating this business.
I'm pop.
I want to see it happen, but I want to see it happen the right way.
Right.
And not get hurt by it.
And just having been there for 20 years, we have a front row seat to that intersection, and we have seen countless numbers of accidents. It's sad that nothing's been done as of yet to solve that problem, because it is a big problem. There's accidents there all the time. People, like the gentleman said before, I'll make a right sometimes out of there, even if I'm trying to go left, because it's sometimes impossible to make a left out of there. So that
I would love to see his traffic analysis. I would love to see that happen. Like, where will these cars go? Will they clog up that whole corner? And, we were told, oh, well, all the traffic coming from the north, it'll go right in, it'll go right in. I'm like, well, what about the traffic coming from the south? Well, you guys have the access road to your restaurant. Well, they'll try to go down there too, Maybe there needs to be another access road behind the buildings, or I don't know the solution, but I don't feel like this solution is the best solution. And I want to see it there. I just don't want to, I just feel like that's a clogging potential, a very big clogging potential.
When their drive-through's full, do they know, I mean, we can envision it coming all the way around the building and out into the access road, people lining up. That would be a lot of vehicles, I assume, if it were to fill up that whole parking lot. Maybe that's
Well,
not feasible.
I've been to DeLaus Chick-fil-A, and they backed up right onto West Ridge Road.
Onto the road.
To the access road, you know,
Yeah.
and that wasn't during, when they first opened either.
It's presently happening?
We just have, I'm sorry to interrupt you, but we have to make sure comments are captured on the record. So I think what we just, that's okay. I think just to repeat, so
I mean, their fears are founded.
Eileen Anderson just commented that she's been to the Grease Chick-fil-A and there were backups there onto the access road.
This being different from the Irondequoit and the Henrietta Chick-fil-A's, and that they have a mall parking lot behind them, and they have places to spill out over into. This one doesn't.
But it does seem to me that there'd be a large number of cars could fit into that part, into the drive-through lanes before it would actually spill out into that.
Which I think in the future would be fine.
So I don't know how many cars they expect, but anyway, those are our concerns, parking and traffic flow. But we are not against the project. I want to make that clear.
Just to clarify that question, you guys had that, how many cars queue in the 3-lane driveway, or the 3-lane drive-through?
The queue, yeah.
I think you had that number somewhere at some point.
Randy Bebout, Bowler Engineering. Yes, the approximate number of vehicles in the drive-through is mid-30s that are within the drive-through lane. That doesn't count any additional capacity that would be out, if it, early in the process, in a grand opening, they would be spilling out. If they were to spill out, they'd be spilling out into the drive lanes within the Chick-fil-A project area.
So the drive lanes are the tan section on that.
That's correct.
Illustrated on the map, okay.
And 30 cars fit in that tan section.
Yeah, we're about 35, 36 cars. I mean,
seems like a
again,
lot.
the spacing,
They said they
we
do.
design for 20. It's not always 20, but the physical measured distance provides for that capacity.
And Randy, if I could add, our traffic analysis looked at how many cars we anticipate queuing, and it's based on the traffic that was measured at the Grease and Cicero sites, and we don't anticipate more than 19 cars maximum on a Saturday queuing. And that's part of the reason for the 3 drive-through lanes. So the trip generation for a Chick-fil-A is not based on the number of drive-through lanes. It's based on the size of the building. That dictates how much traffic it will generate. The purpose of the 3 drive-through lanes is to reduce the queuing and allow the vehicles to get through quicker so that they're not sitting there for as long.
How many cars wait in line at one given time on a Friday night dinner hour? Can you say that?
The average that we measured at Grease and Cicero was 8. The maximum was 14.
At one time, they're not?
Correct.
How do they possibly spill out over onto Ridge Road then?
The only thing I can add to this, because I actually live in Greece, I mean, certainly when this opened, everybody knows the story, but my recent experience in speaking with others, it rarely flows out to the road anymore. And fact of the matter is, that was a single-lane drive-through that bumped out to 2 at the order points, that went back to 1. They have recently added a second lane that further mitigates those issues.
Grease was also the first Chick-fil-A store in the area, so it was,
That was the big buzz.
yeah, there was a lot of traffic when it first opened, and now there's 3 others now.
So that Grease location originally had 1 lane, where this has 3 to start with?
That's correct.
Correct, okay.
And it's a much smaller site.
Okay. The parcel itself is
Yes.
for cars to sit in?
Yes.
Okay.
So just to clarify, you're outside of the traffic, which I appreciate you kind of mentioning the queuing, because I think that's important. Your bigger concern sounds like it's more the in-plaza traffic.
Well, exactly, because we're in the in-plaza traffic. I want there to be, if there's so much traffic going, 1,500 cars a day going in and out of Chick-fil-A, will our customers be able to get into our restaurants?
Do you remember that when we had the car wash that was put in they put in a gate that they could close so that the overflow from the car wash wouldn't impact the other vendors? I don't remember exactly which plaza it was.
Baytown.
Baytown. Have you had these conversations with the Chick-fil-A about maybe some traffic control patterns they could put in to assist you so that you didn't have to worry about overflow and your customers not being able to get in?
Well, that would be great. We don't own the land.
Yeah, but as a business owner, you and the landowner could have a conversation with Chick-fil-A about putting in some, there may be some options we're not even aware of. Just putting it out there, they could have that conversation and maybe, tackle some of your concerns.
The biggest problem is they're busy. Their busiest hours are our busiest hours too, so everyone's doing the same thing.
Yep, just an idea, just a recommendation.
I guess I'd take that a little further and ask Chick-fil-A whether it would commit tonight if, I'll say it a third time, if the application is approved, would you commit to sitting down with, communicating with not only these folks, but other tenants in the area to certainly minimize any impacts during a construction period, and also as the operation proceeds forward?
I mean, we would definitely be agreeable to meeting with the neighbors. If this project was approved and we're starting construction, yes, we can work with them and, they can understand the intent of how that construction sequencing will work. And just, to add, Chick-fil-A's team members are out there taking orders, and I'm confining this to the Chick-fil-A parcel, the Chick-fil-A drive-through. They're helping direct traffic where they need. They're not going to go into the neighbor's property and direct traffic, but they are controlling traffic and moving people along as efficiently as possible within the Chick-fil-A drive-through itself.
Okay. All right, thank you for coming up on that. Thanks for listening. Any questions for these folks? No? All right. Thank you. I'm out of sign-up slips, but I will ask, is there anyone else in the audience that cares to speak about this application? Come on up, ma'am. Okay.
Hi, my name's Donna Spinella, 39 Scarborough Park. I'd like to go back to a point that was made a little earlier with respect to notifying residents who might be affected by this particular project. And it goes to sort of a broader issue that I think needs to be addressed, but specifically on this one. And I'm sorry, I don't know your first name. Christine, sorry. So Christine clarified that there were at least 3 or so different distances out from a project for which residents would be notified, 500 feet, 1,250 feet, 750, all the way out to 1,750 feet. And it depends on the acreage, if I'm not mistaken. But one important question, I think, is does it depend on the intensity of usage of the property and not just the acreage? The acreage of property, if it's going to have professional offices on it, is very different from the intensity of usage if it's going to have a fast food restaurant with drive-throughs and so forth.
Yeah.
And so if these regulations or guidelines that were set down apparently years ago and have not been updated are going to be applied in this case, did the town really do its due diligence in notifying residents? If they're using an old set of guidelines that doesn't take into account the current array of businesses there that have multiplied greatly over the years on 250, and also doesn't take into account how intensely the property is going to be used because of things like traffic and safety and so forth. So I'm throwing that out to you and asking you specifically on this project to review those and look at this project under those sort of newer sort of guidelines, and also to apply such guidelines in the future to other similar projects, because we know that these things will be going on and on and on, particularly in that area.
So, okay, fair point. What I would say about that is, Christine was mentioning the process used for the notification.
Right.
That is germane, perhaps, to this application, but those aren't the standards that we're going to use to consider these applications. So, in the future, should the town look at it if it hasn't been updated in a while? Sure, why not? But I just want to clarify that what she was talking about was not the same issue directly that both council were talking about in terms of standing. Those are, they're two distinct issues. She was talking about what process is used to decide who gets a postcard. And frankly, probably because some of the issues that you've raised about the notification, that's why the town does those other things that I mentioned earlier about publishing the agenda, having the applicant put the sign out, not relying on one method to get the word out, so to speak, but using several different methods.
Point taken. But I was not referring to standing either.
Okay.
I'm referring specifically to notification of residents. And I have to say that putting a sign out if someone is driving by quickly is not super helpful. Putting a notification on the web is something that a resident has to actively go to and seek out. You need a push communication for something like that, and a push these days is either snail mail to their door or email to their homes or text to their phones. It's something like that that they don't have to go fishing for.
Yeah.
We have elderly residents who are not tech savvy. They're not necessarily going to check the website. And again, people going home to bring their kid to soccer practice, to go home and make dinner for the kids. They're not going to be looking, hopefully they're not looking at too many road signs and they're getting home safely. So I think that new standards need to be put in place, but I also think that you would consider in your mind the fact that there would probably have been a lot more residents showing up at these meetings had they gotten out a push communication further away, taking into account the intensity of use of this piece of land.
Point taken.
Thank you.
Fair enough. Any questions? I'm sorry, any questions for this witness? All right. So I will ask, again, I know somebody else. Hold on a second there, Mr. Young-Wiedemer, because you had your hand up that I saw you, right? You want to speak?
Well, I just was going to bring up another possible.
Come on up and give us your name and address. And
I'm Lorraine Palmieri, 23 Bramblewood Lane, again. So Bramblewood is off Pembroke Drive.
Right.
And there are people that use Pembroke Drive as a cut-through to avoid 441 and 250, those that are maybe coming from Gananda or east of us and trying to get to Webster. So I just see that as, and they go fast, and there's the apartments and the kids, and then there's, so I think that's another possible impact that could directly impact our community with the apartments and with the single-family homes. You get a lot of that cut-through traffic on Pembroke just to skirt around. So I see with Chick-Fil-A and all that added traffic, that would even increase, or could.
okay.
That's it.
No, any questions?
No, sir.
Thank you.
Thank you.
All right. Sure, now you can come up.
Appreciate the compliment of my youth, Mr. Chairman.
Well, it was really not so much about your youth.
Yeah, I got it.
Yeah.
Well, good evening, and fellow board members. My name is Mike Wiedemer. I reside at 39 Dumais Lane. My wife, Megan, and I grew up in Penfield, and when we were married and decided to have a family, We had to live in Penfield. We had to make that family here. And just 3 years ago, we built our forever home right near Whalen Road, Dumai Lane, new street that went in 3 years ago, about 1.5 miles from the site we're talking about this evening. And we chose that site because we wanted to live in the heart of the town that we've always called home. As you mentioned earlier, distance matters, and we consider that area to be the heart of Penfield. I happen to work at a company that's located near Eastview Mall, so between commutes to work and family activities and errands, our family probably drives by that site 25 times a week. We also bike regularly. We've got daughters who are ages 12 and 9. We love biking to the destinations in that plaza, getting ice cream at Penfield Pub. And we're only a few years away from having teenage drivers in the house. So I'm here tonight because I do believe the outcome of this decision will have direct impact on the quality of life for those of us who live nearby. And as one of those residents, I would recommend that the zoning board deny the appeal and allow Chick-fil-A's site plan and their application to proceed for 2 important reasons. And I'll be brief. I know you've already heard from a number of members of the audience tonight, but the first reason is public safety. The corridor clearly needs a traffic signal. Chick-fil-A is prepared to make that investment. There are very few businesses that would step up and make that investment to improve the safety for $1.5 million. It's an investment that will prevent accidents, it will save lives, and I would always urge the town board and the boards of the town to make the safety of the community its top priority. Penfield, to remain a community of choice, needs to be safe for families and seniors. The second reason would be economic vitality. I think Penfield needs to be attractive to and inclusive with businesses and entrepreneurs of all sizes. Like many in the room, I believe it's important to repurpose existing sites whenever possible, which is exactly what this project is proposed to do. I recognize the traffic concern. I'm going to live that traffic as someone who passes through that site as much as anyone does. But I do strongly believe that the benefits outweigh the trade-offs. The project will bring a well-established brand, steady tax revenue for the town, flexible part-time jobs for residents of all ages. So I'm in favor of the plan. Penfield needs a permanent solution for the site. We have one with this application. I have no agenda other than lifelong resident living a mile and a half away, a father with 2 kids, and I appreciate everyone's work and consideration. Thank you.
Any questions?
No.
All right, thank you. Anyone else? Come on up, sir.
Call him young man. I actually, my name is Jeff Mordacy. I am a Penfield resident. I actually echo a lot of the same comments that was just brought up. As a father of 3 young children, it is difficult for me to attend and participate in these meetings, but I thought it was important for me and my wife to adjust our family's schedule in order to come out and offer my support. Judging by the fields outside, I think there are a lot of people in my similar situation that are not able to adjust their schedule and provide support. I offer my support for several reasons. The most critical is the traffic improvement. I have witnessed accidents firsthand in this area several times, several near misses, similar to what everyone else has said. A new traffic light will significantly reduce the potential for future accidents. I know it will slow speeds, as people said. I think as a result of that, you'll have less accidents. You're not going to eliminate accidents. There is no such thing as a magical light. But I think even one less accident or injury is worth the investment. Second reason I support this is that economic development with strong partners offering to invest in our town, providing jobs for our people while generating tax revenue, again, for our town, is crucial for Penfield's short-term and long-term well-being. I ask that you approve the Chick-fil-A application to ensure economic stability for our town.
Okay, any questions?
No.
Thank you.
Yep.
All right, anyone else in the audience care to speak about this application, or these applications, I should say? No, all right. So I don't see anybody on the phone with call-ins. There are 2 comments submitted electronically. The first one is from Daria Reitneck of 1817 Baird Road. And I'll just read it, it's not very long. Being a Penfield Business Chamber board member for 9 years and a Penfield resident for over 25 years, I have seen the Penfield business community grow in a positive direction. Having a Chick-fil-A in Penfield would provide added revenue to our tax base, employ many Penfield residents, plus provide the town with a much-needed traffic light at their proposed site. Growth is good for our community. Chick-fil-A wants to be in Penfield and wants to comply with the town's requests. Let's allow the town of Penfield to continue its growth and allow Chick-fil-A to become a responsible Penfield business. The next comment is from Michael Bocuzzi, 55 Hilltop Drive, Penfield. He says, or writes, as a lifelong resident of Penfield, I believe the addition of a Chick-fil-A to the area will improve the area and give the residents of Penfield another much-needed option for food in the area, and will eliminate a vacant building that is becoming an eyesore to the area. The addition of the traffic light will also improve the safety of drivers turning north out of Parkside Commons, something I have found too difficult at best at times. It will also slow traffic approaching 441 and 250. The slower traffic and breaks in traffic will improve getting into and out of Penn Fair Plaza and the post office onto 250. That is it in terms of electronic comments. So, all right, we've handled both applications simultaneously. I thank everybody for their patience and cooperation. A lot of good information and opinions received. We will then close both public hearings and move on to the consideration. And we'll start. Anybody need a break?
No. Good.
Okay. We'll start with the application listed as number 3, and that is the appeal of the determination by the town of Penfield authorized official. In essence, the applicant Preserve Penfield has made a challenge to the decision by the town official that the underlying code and the overlying district, there was a conflict there, and because of the conflict, she rendered an opinion that the application of the underlying district to Chick-fil-A's project would result in a safer environment, let's say, down there. Counsel for both Chick-fil-A and Preserve Penfield have filed extensive legal papers outlining all the arguments they've made. They've both done an excellent job bringing to bear the issues. This matter, and I say matter because it's really one application, has been on our agenda since December, and it's also on the Planning Board's agenda. So again, I do want to thank everybody involved with the process. This is the way you heard me say at the very beginning, how we appreciate the input of all citizens for and against projects, for and against applications. This particular one is in some ways complicated, in some ways not so much, but there are a lot of details. And there are a lot of legal issues. So my first motion is going to be a legal issue regarding to the environmental. You've heard us make these on some of the other applications. And so as far as this one is concerned, the appeal, I am going to make a motion to, under seeker, the environmental law, to declare this a type 2 action requiring no further review.
I'll second.
All right. Any further discussion on seeker? All those in favor of the motion?
Aye.
All right. And the second motion I'm going to make is a motion to dismiss the appeal brought by Preserve Penfield. And the basis for that motion is my position that the applicant has failed to meet its burden to demonstrate that it has standing based upon being aggrieved or interested as required by law and the Penfield Code. Specifically, the applicant, that is Preserve Penfield, has not presented sufficient proof that any of its members will experience harm or detriment beyond that which would be suffered by the public at large. And you've heard a lot of talk about the legal tests that are required to demonstrate that such harm has occurred. I believe there is no showing that the members named in the submissions will suffer any detriment at their home from the use that is proposed. I say that because we've talked a lot about distance. The law talks about proximity, and there is no evidence in the record that these folks will, while at their home, experience any detriment from this project. Is there evidence that they'll experience the same potential impacts as other members of the public? Absolutely. They drive through there all the time, just like other people we've heard from. But that's not the burden of proof that must be met. They must show, as we've heard, that the members of Preserve Penfield will suffer harm beyond that which will be suffered by the public in general. And my position is they have not met, not for lack of trying, but that they have not met that burden. Similarly, it's my position that the applicant has not presented sufficient evidence that any of its members use the nearby park at a frequency greater than typical users of the park or in a manner different than the public at large. That's an important point on the issue of use of the park somehow conveying standing issue on the members of that organization. Somebody tonight, I forget honestly who it was, stated that it's not just members of Preserve Penfield that are impacted by this, and that's a fair statement. That's a true statement. But again, the test to determine whether the applicant has been aggrieved or interested is that they're experiencing detriment beyond that of the public at large, and I just believe they simply have not met that burden. So, again, my motion would be to dismiss the appeal for the reasons stated.
I'm going to second that. I guess I agree with, I think you said it better than I was trying to allude to before. I also was at that point of, I didn't sense the difference between the public and the Preserve Penfield members. I didn't see the difference of the actual injury that would occur from this or harm, as you said, and I think I agree with that. The counselor for Chick-Fil-A, I think I sided more with what that thought was, that sounded a little more logical to me in terms of, I think if it was, before a judge, I think they would say the same thing as, what is the actual injury? And, is it specific enough to be measured? And I don't know if the preserve Penfield was able to say, this is our measured injury that would occur from this. And I think that was a little bit of, I was trying to get more substance of what that was, and I didn't receive it, or I didn't understand enough of it to be able to grasp enough of that injury to where I really sensed it was different than anybody else in the public driving through.
Okay. Any other comments from board members?
No.
All right, so we have the motion that I've made and a second. Any further discussion? All those in favor? Aye.
Aye.
Any opposed? No. Okay. Well, the passage of that motion then renders the second issue that we've discussed today, that is the merits of the town official opinion regarding the conflict and safety, renders that moot. So we will then move to the original application by Chick-fil-A for the number of variances. And there, I will make a motion regarding the variances. The first variance, I would make a motion to approve the request for a variance regarding the number of parking spots.
Mr. Chairman, if I could just for a moment, you may want to take another seeker on the actual.
Oh, right, we didn't do that, did we? Okay.
And if I may just remind the board, I think at the December meeting, there were some conversations about the actual variance requests regarding the signage on the building.
Can you just go over the request one more time?
Sure, I'll do that, but elaborate on what you just said, other than the seeker. I know I screwed up.
I recall there were some conversations at the December meeting between the board and counsel for Chick-fil-A about some of the requests, the variance requests themselves, such as the signage, the size of the signage, that type of issue.
Okay. You're talking about requests for further information?
Just the question is whether or not they had to have certain signs on different sides of the building.
Yeah, I believe we talked about limiting the number of signs on the building, and I think there's a welcome sign that we talked about, asked if that couldn't be done as a window decal or something, rather than having an additional sign.
That was a request. I don't know if you have info on that or not, so thank you, counsel. At the December hearing, which I rewatched last night, on the north side of the building, there is a request for 2 signs. One of them is the welcome friend sign. And I think it was Mr. Piston that asked, hey, can you take that welcome friend sign and put it in the window, which actually takes it out of the definition of sign, I think, Andy. Is that a fair statement?
Signage inside the window is not regulated.
So I don't know if you have any comment on that or not.
Good evening, Zach Middlebrooks, 5200 Buffington Road in Atlanta with Chick-fil-A. We can definitely do something with that sign. That's more of just a kind of a feel-good. We put it right over our bench. We have a bench out front. That goes back to Truett and some legacy that we have. We even have a bench out front of our corporate office. So it's more of a kind of something we do, just a neighborhood thing. If we need to get rid of it, we can find another place, but I kind of defer to you guys.
Yeah, so.
And it'll have, like, we put the town, so it'll be like welcome friends and neighbors, town of Penfield or whatever, right, and make it kind of unique to the.
Just want to make sure you understand the request that was made, because it's a little, if it's a decal on the inside of the window, then it's not a sign that you have to worry about in terms of the number of signs allowed on the building. So that was the specific question that was asked, is can you just take that make it a decal and put it on the inside of a window or the inside of the door, which it looks like is planned to be a clear door.
Yeah, so we certainly can. Again, it just, the way it goes right there is just right over that bench. And
Right.
that bench is oriented so that it doesn't impact travel patterns on the sidewalks. If it's a major deal with the town, we can take it off. Again, it's just a little, kind of a little niche thing that we do.
Yeah, I don't think anybody opposes you putting it on the inside, because it is a nice little sign, I guess. But it does eliminate a building-mounted sign and therefore reduce that aspect of your request for a special permit.
I would ask if we could keep it, if that's for consideration, but again, I wasn't at the December meeting, I apologize.
Yeah.
So, yeah, if it needs to go to a graphic.
So then my question would be, the goal here is to reduce the number of exceptions that are necessary. So is there another one of the signs that you would say we would give up?
I would take that one off before I give up another one.
I'm sorry?
I said I would prefer to take that off before another one, and that's a fair question.
Yep, thank you.
Yep.
And what elevation is that?
That'll be the parking lot, so right when you come from the parking lot.
So that's facing north?
Right, so it's more geared to the dine-in customers.
Okay. All right.
I don't have a particular problem with that sign, but is it on all of your, every Chick-fil-A?
We put it in as many as we can. Some of the prototypes, we're not able to get that bench, and it kind of goes with the bench. But yeah, it's all the recent ones we're doing are including that.
Okay.
So it's almost like nostalgia.
It is. Yeah, so at our corporate office, there's that exact bench with Truett sitting on the bench drinking a lemonade. And it just kind of goes back to the roots of Chick-fil-A.
Okay.
I guess it doesn't have the reason why I'm less concerned about that one is it's not because you're trying to advertise Chick-fil-A and giving preferential treatment with more signage than a typical business that we would have in that plaza.
So 2 questions. So that's a much lower signage, which isn't, so it is definitely different than the other signage on the building. And, how would we respond if somebody wanted to put something similar on another?
Let me interrupt you and just say we've actually closed the public hearing. So we had a question for clarification as part of the motion. Let me complete my motion, and then let's entertain this discussion, if we could. But in interest of fairness to everybody in this room, I'll ask if anybody wants to talk about this specific issue that's been raised in the last minute and a half, and that is this sign on the north face, because we did actually close the hearing and then kind of reopened it. Anyone here?
Just that the same area variance standards would apply.
That's well taken, fair enough. Okay, let me complete the motion then.
Secret.
Yes. So on the seeker motion, right, I'm going to make a motion to declare this an unlisted action and to further issue a negative declaration on the project.
Second.
All right. Any further discussion on the seeker? All those in favor?
Aye.
Okay. So moving to the variance, area variance requests. The first one I'm going to make a motion on is to approve the request for a variance regarding the number of parking spots. The main reason for my motion to approve is the my opinion that the parking requirements, frankly, that apply pretty much throughout the town are something else that probably should be looked at and updated, just because the nature of business has changed so much over the years, and in particular businesses like this. The required number is 181. I think if the store were full of people, including employees, the testimony from the last hearing was that there'd be about 125, 130 people. And not all of them, obviously, would be using a car. So 181 is just That may be what's required, but it's a really high number. So the requested number of 88 leaves a variance of 93. My motion is based upon the evidence presented by Chick-fil-A that they've conducted a review of their needs from other local Chick-fil-A's, as well as I've already said, the changed circumstances of fast food restaurants over the years. Specifically, that people don't go into the restaurants nearly as much as they used to. And I would note that we had a similar application by the McDonald's further south, and we granted that motion. So I think it was done largely so they could add another drive-through. Again, recognizing the change in how fast food patrons are served. And finally, the point that I would make here in terms of impact is that fewer spaces means less asphalt and a more efficient and safe drive-through system. So that's the first aspect of the motion, and I'm going to make a motion that covers all the area variances. The second aspect of the motion is to approve the request for a variance for the canopy. Frankly, one of the, in my opinion, easier issues that we deal with on this application. The neighbor to the south is a commercial operation, and there's no indication in the record that there'd be any adverse effects upon the use of that tenant, neighboring commercial use from this variance. The canopy is built and constructed in such a way to allow the employees protection from the elements when they're out there doing their job, taking orders, taking payments. It's my position that the variance is not substantial, which is one of the factors that we have to consider in the sense that it's for the canopy only and not the building. And I've already mentioned the providing cover for employees. So that's the second aspect of the motion. The third aspect of the motion for the area variance is to make a motion to approve the variance request for a 35-foot variance from the required 50-foot buffer between districts. I'd first note that this variance request does not involve the building. It involves how close the asphalt is to the neighboring district, which I think is it residential?
Yes, it's zoned, well, the park is zoned residential.
Right.
Yeah.
Ironically, the park is zoned residential, but it is. So that's the one that we're talking about with the need for the buffer. But again, we're not talking about the building encroaching into the buffer. It's the asphalt that's encroaching in, but it's still an encroachment. And by the way, it's also part of the dumpster enclosure, a portion of that. In any event, it's noteworthy, a couple of things. There presently, as we've heard a lot about tonight, exists a service road for behind a large portion of the plaza that's also closer to the park, the residential zoning. We haven't heard any evidence that that service road has caused any problems because it's within that buffer area. And the current the prior use involved asphalt that is actually closer than the asphalt that Chick-fil-A will use. It's only by a couple of feet. But I raise that point because the asphalt is actually going to be, if you will, pulled back a couple of feet from the asphalt that exists now. So they argue that they're actually improving the situation. Okay. And then The final point I'd like to bring up in support of the motion is that there is significant and will continue to be significant buffering in the area in the way of trees. All right, so those are the motions about the area variances. I will have a separate motion on the sign package, but.
I'll second those.
Okay. I will also, I'm sorry, I will add as a requirement for this motion, and probably my next one, that Chick-fil-A confer with other plaza tenants, as we've talked about, regarding mitigating impacts during the construction period. That's a requirement of my motion to approve these. All right, so that's an amended motion to approve, and we have another second. Any further discussion on that? All right, all those in favor of that motion?
Aye.
Aye.
Any opposed? No. Okay. Can we pull up the north elevation again, Andy? That's the elevation that I...
Yeah, actually, I'm going to, this that I pulled up is, the signage represented on this elevation is different than the original sign package. This is showing.
Didn't reflect what was submitted for the zoning board.
Right, so I've got, here is the actual sign package here. So we've got this on the north elevation. This would be the east elevation. And then the south. So there's 3 total signs, plus the welcome sign.
Right. So, all right. So this is a request for a special permit regarding signage, as Andy just said. I certainly understand the requests for building signage for many purposes, including attracting customers. But I think that this board has always considered the flow of traffic when signs are requested on buildings within plazas. And that's an important factor for me. So when we talk about safe travel, so in my mind that raised the question, what signs are needed to help customers identify and get to that building? And because of that, I'm okay with a sign on the, would you say there's one on the south side?
Yep, there's one over here.
Right. That makes sense because cars are going to be coming from the south to get to the building, both from 250 and then from other areas of the plaza. Then there was one on the east side.
Yep, the 250 side.
Yeah, I think probably to a less degree, that one, but it still serves the purpose of identifying that building, certainly from the road a little bit. I just don't see that the applicant has met its burden of showing a need for the chicken sign, whatever it is, the chicken sign on the north facade. You know, the welcome sign, I don't have a problem with it for the reasons stated about the desire of that. That's certainly less for identification and just more for a, let's say, community spirit purpose, which I don't have a problem with. So that aspect of the request for a sign package, the 3 building signs, my motion would be to approve those. And then regarding the pylon sign, there are 2 requests there. One is for a sign larger than allowed, and the other is for a setback. And my motion would be to approve both of those aspects of the package request. And the reason is simply stated for safety and identification. We've heard a lot of talk tonight about the importance of that entrance. And people on 250 need to know that that's the preferred method, the suggested method to get to Chick-fil-A's to turn in that intersection. And because of the design of the proposed driving lane there, it really limits where they can put the sign. And therefore, the setback variance, in my opinion, is appropriate. There's no detrimental effect on that. In fact, it makes it more effective, and therefore, again, provides more safety for people traveling and looking to identify where Chick-fil-A is. And the same argument applies to the size of the sign. We've granted similar variances, not only in this area, but also in other commercial areas up and down Empire Boulevard, as well as further down 441 and 250. So again, the main focus for my motion to approve is safety and allowing people to identify the building. But I just don't think that they've made that case for the one on the north side. So that's my motion on the sign package.
I'll second.
All right. So we have a motion to approve the sign package as noted. I'll add it again to put the same requirement in there about talking with other tenants to mitigate the impacts from the construction. I'm assuming that second carries that as
Yes, sir.
well.
I'll second.
Any further discussion on this? Okay.
I'm sorry, can I clarify?
Yes.
So the approval for the building mounted signage is for all of them except the one on the northern elevation?
Correct, the chicken one.
The chicken sign,
And if they decide they don't want the welcome, that will leave them with 2 building mounted signs. That's up to them. In other words, to me, my motion is that sign, welcome, can be on the outside of the building. I think they've heard from us that if it can be a window decal, that would be preferred, but I'm okay with it. As long as the other one is removed, I'm okay with them having the welcome sign. The chicken sign on the north end just not needed at this point. Doesn't mean they can't come in the future, but mostly there's trees there as people are coming from the north. By the time they get to the point where they'd see that sign, they'd be past it and they'd be looking at the pylon sign.
Pylon sign there,
Yeah. Got that, Andy?
Yes.
Okay, good. All right, so we have a motion to approve as I've described in a second. Any further discussion? All those in favor?
Aye.
And I think that is it, unless I've missed something. No. Okay. Again, I've been doing this for a lot of years, much perhaps to the chagrin of some people, but I do want to thank everybody for all their dedication and hard work. I'll tell you, I've heard from a lot of people in the community, it's a Chick-fil-A. What's the big deal? No offense to Chick-fil-A, but it is a big deal. We've had a lot of reasonable people here with reasonable beliefs and opinions, impassioned to a certain degree, and there's nothing wrong with that. That's the way it should work, because that shows that people care about their community. Caring people, passionate people can have different opinions. And again, to me, that's what it's all about. So I thank everybody.
Do we need to do anything with the Atlantic Ave? Do we need to?
Yep.
Because that was a no-show.
Yep.
And they tried calling.
We'll call that again, and then we'll decide what we're going to do on that. All right, but that ends the applications regarding Chick-fil-A and the appeal tonight. Thank you. So.
PCTV tried calling. Went to voicemail.
Oh, they did?
Yeah.
Okay. So getting back to the first application listed tonight, I'll note for the record again, anybody here for application number 1? I'll ask again. Okay, great. Thanks, folks. I'll note for the record that staff previously informed the applicant that this board needed a updated survey in order to entertain this application. And after receiving that notification, nobody appeared tonight. So I'm going to suggest that we take the lack of appearance from people that have been here before and know that it's important and, I guess, required for them to be here. I'm going to take the lack of appearance tonight to mean that they are working on getting that survey. And I would ask staff to confirm that tomorrow. So given that, I'm just going to, I don't know that we need a motion to table, or we can just kind of keep it on our agenda.
I believe you can just adjourn it to the next.
Okay, yeah, let's adjourn it, and if everybody's okay with that,
Yep, I
adjourn
agree.
it to the next meeting. Okay, anything else? All right, very
Does
good.
it need to be a motion and vote, or no? Just,
It wouldn't hurt.
All right, I'll make a motion then to adjourn the 3408 Atlantic Avenue application.
I'll second.
Fantastic. I'm surprised Andris didn't try to second that one, too.
Yeah.
All right. We have a motion to adjourn and a second. All those in favor?
Aye.
All right. Great job, everybody. See you next month. Thank you.